Corbin Ashwell smirked at me across the courtroom the moment the judge finished reading her ruling, a satisfied, victorious expression spreading slowly across his face as he watched nearly a decade of marriage dissolve into a settlement that left me with almost nothing while he walked away with our family's entire financial foundation intact. He leaned toward his attorney, whispering something that made them both smile, clearly believing he'd successfully, permanently gotten away with months of calculated lies he'd told under oath throughout our entire divorce proceedings. He didn't even bother glancing at me again as he gathered his briefcase, his posture radiating the particular ease of a man who genuinely believed the hardest part of his life was now finally, comfortably behind him. What Corbin didn't know, watching me gather my own belongings in what he assumed was defeated, resigned silence, was that I'd been recording our private conversations for the past 4 months, and I hadn't yet shown my attorney the footage that would completely unravel everything he'd just secured in that courtroom. Stick with me, because that smirk was about to become the very last moment Corbin Ashwell ever felt genuinely victorious about anything again. My name is Marguerite Holt, though everyone in my life has always called me Meg, and has for as long as I can remember. I'm 36 years old, and for 9 years, I was married to Corbin Ashwell, a man whose calm, endlessly reasonable public demeanor throughout our marriage had gradually revealed itself, particularly throughout our increasingly contentious divorce proceedings, as a carefully maintained performance masking considerably more calculated, dishonest behavior than I'd ever genuinely recognized during our many years together as husband and wife. Corbin owned a successful commercial real estate development firm, Ashwell Properties, that he'd built steadily throughout the entire span of our marriage, initially with my own significant financial and practical support during its earliest, most precarious years, support that included years of my own steady income covering our household expenses in full while Corbin reinvested nearly everything his early ventures generated back into the growing business, an arrangement I'd agreed to gladly, because I genuinely believed in what we were building together as partners. Throughout our divorce proceedings, Corbin had testified under oath, repeatedly and with unsettling composure, that his company's current value remained considerably modest, that his personal income had declined significantly over recent years due to challenging market conditions beyond his control, and that I had contributed only minimally to the marriage's financial foundation beyond basic household management, testimony that painted a picture entirely disconnected from the actual reality I'd personally witnessed, lived through and contributed toward throughout our 9 years together building both a marriage and I'd always believed, a shared enterprise. I'd grown suspicious of these specific claims roughly 6 months before our final court date, suspicions that eventually led me to install a small, entirely legal recording device within our shared home office, a decision made carefully, deliberately, and with proper legal guidance, one that would ultimately provide the exact evidence needed to expose Corbin's extensive, calculated deception throughout our entire divorce proceedings, evidence I chose, with my attorney's careful counsel, to hold in reserve until precisely the right moment arrived. I remember sitting in that courtroom, watching Corbin's shoulders relax visibly the moment the judge finished delivering her ruling, watching him exhale in a way that told me, more clearly than any words could have, exactly how certain he'd become that his elaborate deception had ultimately succeeded without meaningful consequence. I thought, in that specific moment, about every late night I'd spent those final months reviewing recorded audio files with Selena, cross-referencing dates and figures, building a case we both understood needed to remain entirely hidden until the precise moment it would carry the maximum possible legal weight. Corbin's smirk that afternoon wasn't simply satisfaction over a favorable ruling. It was the visible expression of 9 years spent genuinely believing he could reshape reality itself simply by presenting it confidently enough, a belief that had apparently served him well throughout our entire marriage, and was about to fail him more completely than he could have possibly imagined walking out of that courtroom. I drove home alone that evening, the ruling's official documents sitting on the passenger seat beside me, and sat in my car outside my new, temporary apartment for nearly 20 minutes before finding the strength to go inside. I called Selena from that parking lot, my voice steadier than I genuinely felt. "We're filing tomorrow morning exactly as planned," she confirmed, her own voice carrying a quiet, controlled determination that steadied me considerably throughout that difficult, uncertain evening. I remember looking up at the darkening sky that night, thinking about everything that had led to this specific moment, and feeling, despite the day's painful ruling, a genuine, growing sense that the story wasn't actually finished, regardless of how confidently Corbin had walked out of that courtroom believing otherwise. Corbin and I met 11 years ago at a mutual friend's engagement party, married 2 years later in a modest ceremony that reflected our combined, limited resources at the time, both of us genuinely excited about building a life together that included Corbin's ambitious, carefully articulated plans to eventually launch his own commercial real estate development firm, plans I supported enthusiastically throughout our early marriage, believing genuinely in both his vision and our shared, combined future together as equal partners in every meaningful sense. I still remember our wedding day vividly, a small backyard ceremony at my parents' house, Corbin's vows describing a future built on genuine partnership and mutual respect, promises that felt entirely sincere at the time, promises I held onto throughout even the most difficult later years of our marriage, genuinely believing that whatever tension had developed reflected simply the ordinary stress of building a business, rather than any fundamental shift in how he actually valued our partnership. My father, walking me down that makeshift aisle through my parents' garden, whispered to me just before giving me away that Corbin seemed like a man who knew what he wanted, a comment I'd always interpreted as a compliment, though I've thought about it often in the years since, wondering whether my father had glimpsed, even then, a certain single-minded ambition that would eventually reveal itself as something considerably more concerning than simple determination. I worked steadily throughout those early years as a marketing director at a mid-sized regional advertising agency, my own stable, reliable income covering the overwhelming majority of our household expenses during Ashwell Properties' precarious, uncertain early years, allowing Corbin to reinvest nearly every single dollar the fledgling company generated back into acquiring additional properties and expanding its operational capacity, an arrangement that felt, at the time, like the most natural expression of genuine partnership two people building something significant together could possibly offer each other. I also contributed directly to the business itself during those foundational years, handling marketing materials personally, managing client relationships during evening hours after my own full workday concluded, and taking on considerable administrative work entirely without formal compensation, work I'd always understood as a genuine, meaningful partnership contribution toward our shared family enterprise rather than any formal employment arrangement requiring separate documentation or independent compensation, since after all we were building this together as husband and wife as equal partners. By the time Ashwell Properties had grown into a genuinely successful, well-established firm roughly 6 years into our marriage, employing a small but capable staff and managing an increasingly impressive portfolio of commercial properties throughout the region, Corbin's public narrative regarding the company's founding had already begun subtly, gradually shifting, increasingly minimizing my own significant early contributions in favor of a narrative emphasizing his own singular vision and entrepreneurial drive during interviews and networking events, a shift I noticed but generally dismissed, at the time, as simple, harmless self-promotion rather than the calculated groundwork for later financial deception it would eventually reveal itself to genuinely represent. My younger sister, Camille, who had watched our marriage develop closely over the years, mentioned once, during a quiet conversation at a family holiday gathering roughly 5 years into our marriage, that she'd noticed Corbin increasingly describing the business using language that erased my own role almost entirely, phrases like what I built replacing the what we built together, he'd used so naturally during our earlier years. I remember dismissing her observation at the time, genuinely believing I was being oversensitive, that successful men simply spoke this way publicly regardless of their private appreciation for a spouse's genuine contribution. Looking back, I recognize now that Camille had noticed something meaningful long before I allowed myself to see it clearly, a pattern of quiet erasure that would eventually provide the entire foundation for Corbin's fraudulent courtroom testimony years later. I think back now to specific moments throughout those middle years of our marriage that, at the time, felt like ordinary friction rather than warning signs of what would eventually unfold. There was the evening roughly 4 years into our marriage, when I'd suggested formalizing my role within the company with an actual title and salary, given how much time I was genuinely investing into client relationships and marketing materials. Corbin had laughed, not unkindly exactly, but dismissively, telling me that formalizing things between us would just complicate the tax situation, an explanation that seemed reasonable enough at the time but that I recognize now, in hindsight, as an early, subtle step toward ensuring my contributions remained conveniently undocumented, invisible to any future accounting of the company's actual foundation and growth. There was also a specific dinner party roughly 6 years into our marriage, hosted by one of Corbyn's important business contacts, where I overheard him describing the company's founding to a small group of admiring guests without once mentioning my name, describing instead a solitary journey of vision and perseverance that bore little resemblance to the genuine partnership I'd experienced living through those same years myself. I remember standing near the kitchen doorway, holding a glass of wine, listening to him construct that narrative so effortlessly, and feeling a small, uncomfortable knot form in my stomach that I chose, at the time, to interpret as simple insecurity rather than genuine, accurate intuition about what our marriage was gradually becoming. Our marriage began deteriorating noticeably roughly 3 years before our eventual divorce, Corbyn's growing business success apparently triggering a corresponding shift in how he valued and treated our partnership, increasingly dismissive of my own continued contributions while simultaneously growing considerably more secretive regarding the company's actual financial performance and his own personal spending patterns, changes I initially attributed to ordinary business stress rather than anything more deliberately concerning. I discovered, roughly 18 months before our formal separation, evidence suggesting Corbyn had established several new business accounts and investment structures I'd never previously known existed. Discoveries that initially seemed potentially innocent, standard business practice I simply hadn't been directly involved in managing given my own reduced role within the company's daily operations by that point, but that gradually accumulated into a considerably more troubling pattern once our marriage's genuine collapse began accelerating rapidly throughout that same period. Corbyn filed for divorce roughly a year before that final courtroom ruling, citing vague, difficult-to-address complaints about our marriage's general incompatibility, and a sense that we'd grown apart over recent years, complaints that felt, throughout our entire subsequent legal proceedings, considerably less significant and considerably less genuine than the actual financial motivations I gradually came to suspect were driving his surprisingly aggressive, meticulously prepared approach toward minimizing my rightful share of assets we genuinely built together throughout 9 full years of marriage and shared effort. I remember the specific evening he told me he wanted a divorce, sitting across from me at our kitchen table with a folder of papers already prepared, papers I would later realize had taken his attorney several weeks to prepare, meaning Corbyn had been planning this conversation, and likely the broader financial strategy behind it, long before he ever raised the subject with me directly. "I think we both know this hasn't been working for a while," he said, his tone carrying a rehearsed calm that felt, even in that raw, painful moment, somehow performative rather than genuinely emotional. I asked him, through tears I couldn't fully control, whether there was anything specific that had changed, anything we might address together before deciding something so permanent. He simply shook his head, sliding the folder across the table, and told me his attorney would be in touch regarding next steps, a response so clinically detached from 9 years of shared history that I remember feeling, even then, that something about the entire conversation felt calculated rather than genuinely emotional. I hired my own divorce attorney, Selena Marchetti, who specialized specifically in complicated divorces involving business ownership and asset valuation disputes, someone Selena's own colleagues consistently described as meticulous, patient, and genuinely formidable in cases involving hidden or misrepresented marital assets, beginning what would ultimately become a considerably more contentious, drawn-out legal battle than either Corbyn or I had initially anticipated when he first filed those divorce papers, seemingly expecting a swift, straightforward resolution entirely in his own favor. I remember our first meeting in Selena's office vividly, sitting across from her white oak desk, still genuinely stunned by how quickly and coldly Corbyn had transitioned from husband to legal adversary. "Tell me everything," Selena said simply, sliding a legal pad toward me. "Every detail about the business, no matter how small it seems. Sometimes the most significant evidence hides inside details people assume don't matter." I spent nearly 2 hours that first meeting recounting years of memories. Late nights helping draft proposals, weekend property tours I'd attended alongside Corbyn during the company's earliest acquisitions, client dinners I'd personally hosted to secure crucial early contracts. Selena listened carefully throughout, occasionally pausing to ask pointed, specific questions that made clear she was already, even during that first conversation, building a strategic framework for the considerable battle ahead. I also remember, during that same period, reaching out to several former colleagues and business contacts from those early years, hoping they might remember and corroborate my own significant role in the company's founding. Most responded warmly, genuinely willing to provide statements confirming my active involvement throughout those foundational years, memories of specific meetings I'd attended, proposals I'd helped draft, client relationships I'd personally cultivated. One former client, a property developer named Harriet Solano who had worked with Ashwell Properties during its very first year of operation, wrote a detailed letter describing how I had personally negotiated several key contract terms during a deal she remembered clearly, evidence that would eventually prove genuinely valuable in establishing the accurate historical record Corbin's testimony had so thoroughly attempted to obscure. Throughout our divorce proceedings, Corbin's legal team presented formal financial documentation suggesting Ashwell Properties' current value remained considerably modest, roughly $2 million according to their formal valuation report, a figure that struck me immediately, viscerally, as dramatically understated given both my own first-hand knowledge of the company's recent, substantial property acquisitions throughout the previous 2 years and general industry knowledge I'd absorbed over nearly a decade regarding comparable commercial real estate firms of similar scale, staff size, and market presence throughout our region. Selena, working alongside a forensic accountant she regularly collaborated with on similarly complicated cases, a careful, methodical man named Wendell Trask, began carefully investigating this valuation discrepancy in genuine depth, uncovering evidence suggesting Corbin had potentially structured several recent property acquisitions through separate holding entities specifically designed to obscure their actual value and their direct connection to Ashwell Properties' core business operations. During this particular, high-stakes legal proceeding, Wendell met with me directly on several occasions throughout those months, walking me carefully through the specific financial documents his preliminary investigation had uncovered, explaining patiently how certain property transfers appeared to have occurred at suspiciously reduced valuations shortly after Corbin filed for divorce, transfers that, examined individually, might have seemed like ordinary business restructuring, but that, considered together as a pattern, suggested something considerably more deliberate and coordinated. This kind of thing happens more often than people realize, Wendell told me during one of these meetings, adjusting his glasses as he reviewed a spreadsheet of property valuations. People assume once they've filed for divorce, they have months to quietly move things around before anyone thinks to look closely. The mistake they usually make is underestimating exactly how much a determined spouse, with the right guidance, can eventually uncover. Corbin also testified, during a particularly difficult and emotionally exhausting deposition I sat through personally, that my own contributions to the business throughout our marriage's early years had been minimal and largely administrative, language that felt genuinely devastating to hear articulated so casually, so dismissively, given years of genuine, substantial partnership I'd always understood as absolutely foundational to the company's eventual, considerable success. Work I'd sacrificed evenings and weekends to provide without ever once expecting or requesting separate compensation. I began documenting my own detailed recollection of those early years carefully and methodically, gathering whatever physical evidence remained available after so many years, old emails discussing specific client accounts I'd personally managed, financial records showing years of my own income covering our shared household expenses, photographs from various business networking events where I'd represented the company alongside Corbin, attempting to construct a comprehensive, well-documented counter-narrative to Corbin's increasingly dismissive characterization of my genuine, substantial contributions throughout our marriage and our shared business venture. I still remember sitting in that deposition room, watching Corbin answer his attorney's carefully rehearsed questions with unsettling composure. Would you say your wife played a significant role in building Ashwell Properties during its early years? His attorney asked, and Corbin paused, glancing briefly in my direction before answering. She was supportive, certainly, in the way any spouse is supportive. But the vision, the strategy, the actual work of building the company was mine. I sat there, hands clenched beneath the table, remembering countless evenings spent drafting proposals together at our kitchen table, remembering the specific client accounts I'd personally secured through relationships I'd cultivated over years of careful, dedicated effort. Selena caught my eye across the room, her expression carrying a silent reminder to remain composed, to trust the careful process we were building rather than reacting emotionally to testimony we both understood we would eventually, thoroughly dismantle. Roughly 6 months before our final court date, I grew increasingly suspicious that Corbin was actively discussing legal strategy and specific asset concealment plans during private phone conversations, He continued having within our still shared family home conversations I occasionally overheard fragments of during his periodic visits to collect additional belongings and documents, but never with sufficient detail or clarity to constitute meaningful, admissible evidence for our ongoing legal proceedings, only enough to leave me with a persistent, gnawing unease. I consulted carefully with Selena regarding the legality of recording these specific conversations, learning through her detailed explanation that our state-specific one-party consent laws would allow recording within my own home given certain legal parameters, provided the recording occurred within spaces I retained legitimate access and residency rights to, despite our ongoing separation and divorce proceedings, since the house itself remained jointly titled and I continued residing there. Throughout the entire process, I installed a small, entirely legal recording device within the shared home office Corbin continued using periodically for business calls during his regular visits, a device positioned carefully and legally according to Selena's specific, detailed guidance regarding admissible evidence collection during active divorce litigation, guidance I followed meticulously, understanding clearly how easily improperly gathered evidence could be challenged and excluded entirely from consideration. I remember the specific afternoon I installed that device, hands shaking slightly as I positioned it carefully on a bookshelf where it would remain unobtrusive among Corbin's old business awards and framed photographs, several of which, notably, no longer included any images of the two of us together, having apparently been quietly replaced sometime during those final difficult months without my ever fully noticing the gradual disappearance. I felt genuinely conflicted throughout that entire process, torn between a deep instinctive discomfort with the idea of secretly recording someone I'd once loved so completely, and a growing undeniable certainty that something significant was being deliberately hidden from both me and the court, something I had both a personal and, Selena assured me, entirely legal right to uncover through appropriate means. Over the following months, that small device captured several conversations that would ultimately prove genuinely devastating to Corbin's carefully constructed courtroom narrative, including one particularly detailed discussion with his business partner regarding specific strategies for temporarily restructuring company assets to minimize their apparent value during our divorce proceedings, with explicit, unmistakable plans to reverse these restructuring measures once our settlement was formally finalized and the divorce fully concluded, a conversation that left absolutely no ambiguity regarding the deliberate, calculated nature of what Corbin was actually doing throughout our entire legal proceedings. I listened to that specific recording alone late one night, hands trembling as Corbin's familiar voice, the same voice that had once whispered promises to me on our wedding day, calmly discussed shifting property holdings into his partner's name temporarily, describing the entire scheme with the casual confidence of someone who had never once considered the possibility of getting caught. Once the divorce is finalized, we just shift everything back, I heard him say, followed by his partner's quiet laugh of agreement. I sat in my car outside my sister's house for nearly an hour after first hearing that recording, processing not just the financial betrayal but the sheer, calculated coldness with which Corbin had apparently been planning to deceive both me and the court itself throughout this entire painful process, treating our marriage's dissolution as simply another business problem requiring a clever, dishonest solution. I brought this recorded evidence to Selena immediately upon discovering its full significance, sitting together in her office for nearly 3 hours as we reviewed the complete recordings carefully, identifying specific segments that provided clear, unambiguous evidence of Corbin's deliberate financial fraud throughout our entire divorce proceedings, evidence considerably stronger and more damning than either of us had genuinely anticipated finding when I'd first installed that small device. Months earlier, Selena advised extreme caution regarding how and when to introduce this evidence, explaining patiently that timing mattered considerably given both procedural rules regarding formal evidence disclosure and broader strategic considerations regarding how Corbin's legal team might attempt to challenge the recording's admissibility if introduced too early in the proceedings, potentially allowing them opportunity to construct plausible counter-explanations before the evidence's full, devastating impact could be properly established before the court. We made the difficult, carefully calculated strategic decision to withhold this evidence throughout the remaining trial proceedings, allowing Corbin's fraudulent testimony to proceed toward its natural, formal conclusion, understanding clearly that presenting devastating contradictory evidence, immediately following a formal ruling, would provide considerably stronger legal grounds for appeal and potential fraud charges than attempting to introduce it prematurely during ongoing proceedings where Procedural complications might limit its ultimate impact. Selina explained her reasoning in considerable detail during one particularly important strategy session roughly 2 months before our final court date. Judges are human, she told me, leaning forward across her desk. If we present this evidence mid-trial, there's a real risk the court treats it as simply one more piece of contested evidence in an already complicated case, something to be weighed alongside everything else rather than examined with the full scrutiny it genuinely deserves. But if we wait, if we let him testify fully, let him receive his ruling, let him celebrate his apparent victory, and then present this evidence specifically as grounds for reconsideration based on demonstrated fraud, the court has to examine it with an entirely different, considerably more serious lens. It transforms from contested evidence into proof of perjury. I understood her reasoning intellectually throughout those conversations, even as I struggled emotionally with the genuine difficulty of watching Corbyn's fraudulent narrative proceed unchallenged through months of formal proceedings. This strategy required considerable emotional resilience throughout those final, genuinely difficult months of trial proceedings, sitting quietly in that courtroom watching Corbyn testify confidently, convincingly regarding financial circumstances I knew, through direct recorded evidence sitting safely in Selina's office, to be entirely fraudulent, while maintaining careful, controlled composure throughout that wouldn't inadvertently signal to his legal team that we possessed evidence capable of ultimately, completely unraveling their entire carefully constructed case. Selina and I met weekly throughout those final months, reviewing trial strategy carefully over coffee in her office, and I remember asking her once, genuinely struggling with the emotional weight of staying silent, whether we were doing the right thing by waiting. "I know this feels unbearable," she told me gently, watching him lie under oath while we sit on evidence that could stop it immediately. "But trust me, Meg, if we play this card too early, his attorneys will find some way to muddy the waters, to explain it away, to buy time. If we wait until after the ruling, when he's celebrated, when he's let his guard down completely, the impact will be undeniable, and considerably harder for any judge to dismiss or minimize." Her words steadied me throughout those difficult final weeks, though nothing could have fully prepared me for how genuinely painful it would feel to watch that final ruling delivered in Corbyn's favor, knowing what I knew, holding the exact evidence that would eventually change everything. The judge's final ruling, delivered after nearly a year of contentious, exhausting proceedings, reflected almost entirely Corbyn's fraudulent financial narrative, awarding him the overwhelming majority of Ashwell Properties' formally reported value while granting me a settlement considerably smaller than what genuine, accurate asset disclosure would have legally required, given both my substantial early contributions to the business and our marriage's actual, considerably more significant, combined financial foundation that Corbyn had worked so deliberately to obscure. Corbyn's visible satisfaction throughout that ruling's delivery, culminating in that specific memorable smirk directed toward me as the judge finished speaking and gathered her papers, represented the exact moment I understood, with complete and total clarity, that Selina's careful strategic patience throughout those preceding months had positioned us perfectly for what would come immediately following that formal, and ultimately only temporarily final, ruling. I remember every small detail of that courtroom in those final minutes: the fluorescent lighting overhead, the quiet shuffle of papers as the judge finished her remarks, the particular way Corbyn's attorney patted his shoulder in congratulation, a gesture so casually confident it made my stomach turn even as I understood, with quiet certainty, exactly how temporary that confidence would ultimately prove to be. I thought about all the months of careful preparation that had led to this specific moment, about every late night spent reviewing recordings with Selina, about the discipline it had required to sit silently through months of Corbyn's fraudulent testimony, and I felt, watching him gather his things with such visible ease, a strange steady calm settle over me. The particular calm that comes from knowing something crucial that the person celebrating beside you doesn't yet understand. I maintained careful composure throughout the ruling's delivery, gathering my belongings quietly alongside Selina while Corbyn and his attorney exchanged quiet congratulations nearby, allowing Corbyn and his legal team to fully experience their apparent, premature victory before we proceeded, immediately following the hearing's formal conclusion, directly toward filing the specific legal motions necessary to introduce our recorded evidence and formally challenge the entire ruling based on demonstrated deliberate fraud. Selina filed our motion within 24 hours of that original ruling, presenting the recorded evidence directly to the court alongside a formal, meticulously prepared request for the ruling's immediate reconsideration given clear, documented evidence of deliberate financial fraud that had directly, materially influenced the court's original determination regarding Ashwell Properties' actual value and my own legitimate entitlement to a considerably larger, more accurate settlement share. Reflecting the marriage's genuine financial reality, I remember sitting beside Selina in her office that following morning, watching her print the formal motion documents with a quiet, focused determination that felt like the culmination of everything we'd worked toward those preceding months. "This is it," she said, sliding the completed paperwork into a folder. "Once this is filed, there's no going back to quiet negotiation. Corbin's team will fight this hard, because they know exactly what's at stake for him personally, not just financially, but potentially criminally as well." I nodded, thinking about that smirk, about the casual cruelty embedded in his certainty that he'd successfully deceived both me and the court, and felt, for the first time throughout that entire difficult year, a genuine steady confidence that justice was finally truly within reach. The court's response to our motion proceeded considerably faster than either Selina or I had initially anticipated, the judge scheduling an emergency hearing within 2 weeks specifically to review the newly presented recorded evidence and its considerable implications for the case's previous, now clearly compromised and legally questionable ruling. Corbin's attorneys attempted various procedural challenges regarding the recording's admissibility during that emergency hearing, arguments Selina had carefully anticipated and prepared thorough, detailed legal responses for throughout our months of quiet strategic preparation, responses that ultimately proved successful in firmly establishing the evidence's legitimate admissibility given the specific legal parameters we'd carefully, meticulously followed throughout the entire recording process from the very beginning. Corbin's lead attorney, a sharp, experienced litigator named Preston Kane, argued at length that the recording represented an improper invasion of privacy, that Corbin had a reasonable expectation of confidentiality within what he characterized as his own private business communications. Selina countered calmly, methodically, citing the specific state statute governing one-party consent recording, along with documentation establishing my continued legal residency and access rights to the home office where the recording occurred. The judge, after listening carefully to both arguments, ultimately ruled decisively in our favor, noting from the bench that Corbin's own continued use of a shared marital residence for private business discussions during active divorce proceedings undermined any reasonable expectation of privacy he might otherwise have claimed, a ruling that effectively cleared the path for the recording's full consideration as legitimate, admissible evidence. The judge, upon reviewing the full recorded evidence directly in her chambers, expressed clear, visible displeasure regarding the deliberate fraud Corbin had perpetrated throughout formal court proceedings, her expression shifting noticeably as she listened to Corbin's own voice discussing specific strategies for temporarily concealing marital assets, immediately vacating the previous ruling and ordering a comprehensive new financial investigation into Ashwell Properties' actual current value, an investigation specifically incorporating the newly revealed holding entities and asset restructuring Corbin had attempted concealing throughout our original proceedings. This comprehensive new investigation, conducted over the following several months by Wendell Trask and a team of additional forensic accountants the court appointed independently, ultimately revealed Ashwell Properties' actual value at considerably more than $8 million, a figure dramatically exceeding Corbin's original fraudulent testimony, by a margin that left even the judge visibly startled during the proceeding where these final figures were formally presented, providing the legitimate foundation for a considerably more equitable settlement reflecting both parties' genuine, accurate financial circumstances throughout our entire marriage. I sat in that emergency hearing watching Corbin's composure crack for the first time throughout our entire year of proceedings, his face draining of color as the judge played a specific segment of the recording aloud in open court, his own voice, unmistakable and damning, describing the exact mechanics of the asset concealment scheme he'd orchestrated. His attorney attempted several objections, each one overruled with increasing impatience from a judge who had clearly grown genuinely frustrated at having nearly issued a ruling built entirely on fraudulent testimony. Corbin himself said nothing throughout the remainder of that hearing, staring fixedly at the table in front of him, the confident, dismissive composure he'd maintained throughout our entire marriage and divorce finally, completely abandoning him in that specific, quiet moment. Beyond the corrected financial settlement itself, Corbyn's demonstrated pattern of fraud throughout formal court proceedings triggered additional, considerably more serious legal consequences, the judge formally referring the entire matter to state prosecutors for careful consideration of perjury charges given the clear, thoroughly documented evidence of deliberate false testimony provided under oath throughout our original trial proceedings. A referral that carried genuine, significant weight. Given the judge's own visible frustration regarding how close the court had come to formally endorsing Corbyn's fraudulent narrative entirely, Corbyn's business partner, whose distinctive voice appeared throughout several of the recorded conversations discussing the specific asset restructuring strategy in considerable detail, faced his own separate, significant legal consequences given his direct, active participation in this documented financial fraud, consequences that ultimately included his own formal departure from Ashwell Properties amid the resulting legal and reputational fallout that neither man had anticipated when they'd first discussed their concealment strategy so casually within what they'd assumed was an entirely private conversation. I learned, through subsequent industry connections and occasional updates from mutual acquaintances, that Corbyn's professional reputation throughout the local commercial real estate community suffered considerably once details regarding his fraudulent divorce proceedings became more widely known throughout that tightly connected professional circle, several longtime business partners and clients reconsidering their continued professional relationships with someone who had demonstrated such calculated, deliberate willingness to commit fraud whenever he believed doing so would benefit him financially without any meaningful risk of eventual discovery. A former colleague of mine, someone who had maintained loose professional connections within the local business community, mentioned to me nearly a year after the corrected settlement that Corbyn had lost 2 significant client relationships specifically because those clients had learned about the perjury referral through mutual industry contacts, clients who apparently expressed genuine discomfort continuing business relationships with someone facing potential criminal charges for financial fraud committed under oath. Ashwell Properties itself, I learned, struggled considerably throughout that following year to secure new investment partnerships, several potential investors reportedly citing the ongoing legal uncertainty and reputational damage as specific reasons for pursuing other opportunities instead, consequences that extended considerably beyond what either Corbyn or his business partner had likely anticipated when they'd first discussed their concealment strategy so casually within that recorded conversation. I didn't personally seek these broader professional consequences for Corbyn specifically, having focused my own efforts entirely on securing the accurate, legitimate settlement our marriage's actual financial circumstances genuinely warranted after 9 years of shared effort. But I recognized, watching these consequences unfold gradually over the following months, a certain quiet, complicated satisfaction in seeing genuine accountability finally, unmistakably arrive for someone who had spent nearly a full year confidently, calculatedly lying under oath, genuinely believing his careful, methodical deception would ultimately succeed without any meaningful consequence whatsoever. My sister Camille, who had watched the entire ordeal unfold alongside me from the very beginning, offering steady support throughout even the most difficult weeks, told me once, sitting together on my porch during a quiet evening roughly a year after the corrected settlement, that watching me navigate that entire process had genuinely changed how she thought about quiet resilience and patience. "You could have exploded the moment you found that recording," she said. "Most people would have. But you waited, you trusted the process, and it worked out considerably better than if you'd reacted immediately." I thought about her words often throughout that following year, recognizing that the hardest part of the entire ordeal hadn't been discovering Corbyn's fraud itself, but rather the discipline required to sit quietly with that knowledge for months, allowing the truth to surface at precisely the moment it would matter most. The corrected settlement, finalized roughly 8 months after that original fraudulent courtroom ruling, provided me with financial resources genuinely reflecting my legitimate contributions throughout our marriage, resources I used carefully and deliberately to establish a stable, independent life entirely separate from the considerable stress and uncertainty those long, difficult months of contentious legal proceedings had ultimately required me to endure. I purchased a modest but genuinely comfortable home in a quiet neighborhood roughly 6 months after the corrected settlement finalized, deliberately choosing a space that felt entirely my own, unconnected to any memory of the life Corbyn and I had built together throughout those 9 years. I spent considerable time during those early months simply sitting in that new home's small backyard garden, processing everything that had happened, allowing myself genuine space to grieve the marriage I'd once believed in so completely, even as I felt increasingly grateful for the clarity and independence that had ultimately emerged from its painful, protracted collapse. My mother visited often during those early months of settling into my new home, and I remember her saying once, sitting together on my new back porch during a warm evening, that she'd always sensed something slightly off about Corbin's public confidence, a certainty that had never quite matched the quieter, more genuine partnership she remembered witnessing during our earliest years together. "I never wanted to say anything while you were married," she told me gently, "because it wasn't my place, and honestly I hoped I was wrong. But watching you handle everything with such patience and clarity these past 2 years, Meg, I've never been more proud of the woman you've become." Her words meant more to me than I could easily express in that moment. A quiet confirmation that the strength I'd needed to summon throughout that entire difficult process had genuinely been recognized by the people who mattered most in my life. I remained close with Selena throughout that following year, our professional relationship evolving gradually into a genuine, lasting friendship built through the shared experience of navigating such a genuinely difficult, ultimately successful legal battle together. A friendship I valued considerably given how essential her careful, patient strategic guidance had ultimately proven throughout the entire drawn-out process from beginning to end. I also developed a meaningful friendship with Tobias Renner, the private investigator Selena had connected me with during our case's earliest stages, someone whose careful, thorough investigative work had helped establish crucial foundational evidence regarding Ashwell Properties' actual value long before my own recorded evidence ultimately provided the final, decisive confirmation of Corbin's extensive, deliberate fraud throughout our entire divorce proceedings. I eventually returned to work full-time at my advertising agency roughly a year after the corrected settlement, accepting a promotion to senior director that I'd previously declined years earlier specifically because Corbin had expressed discomfort with my potential travel schedule interfering with his own professional entertaining obligations, a small, telling detail I hadn't fully recognized as part of the broader pattern of diminishment until I found myself, finally, free to pursue that opportunity entirely on my own terms. Standing in my own new home roughly 2 years after that devastating original courtroom ruling, genuinely secure and independent for the first time in longer than I could easily remember, I thought often about that specific memorable smirk Corbin had directed toward me the moment he believed he'd successfully, permanently secured an unjust financial advantage through calculated lies and deliberate, sustained fraud. That smirk, I'd come to understand clearly through everything that followed, represented the exact moment his own overconfidence in his ability to deceive everyone around him without consequence ultimately, permanently unraveled. And I felt, reflecting quietly on everything that had unfolded since that difficult day, genuine, hard-won satisfaction in having trusted my own instincts carefully enough to gather the exact evidence needed to ensure genuine, complete justice ultimately, undeniably, prevailed. I think often, even now, about what I would tell any woman finding herself in a similarly difficult position, watching a partner's confident lies threaten to permanently, unfairly reshape her own financial future. Trust your instincts when something feels genuinely wrong, even when the person telling you otherwise sounds entirely calm and reasonable. Document everything carefully, patiently, and legally. And understand that genuine justice sometimes requires considerable patience, the discipline to wait quietly through a painful, temporary defeat, trusting that the truth, once properly documented and strategically presented, carries a weight that confident lies, however smoothly delivered, simply cannot ultimately withstand.